But right now, from Michel Associates out in California, Clint Monfort is with us. Clint, how are you this afternoon?
I'm doing great. Thanks, Cam. How are you?
I am good. Yesterday was a very busy day for the Second Amendment, both in terms of legislative activity and court decisions. Let's talk first of all about something that's not getting a lot of attention, but I think it is pretty important to note. The Supreme Court, in its orders yesterday, did not mention the Jackson case, which is a case out of California dealing with the gun storage laws in San Francisco. They're apparently going to hold that case over for further consideration and conversation at this Thursday's private conference.
That's right. This will make the fourth time in a row it's now either been rescheduled or relisted for further consideration at a later time. So plainly the court's taking a look at it. It's hard to read too much into it, but the court's definitely looked at it. So we're waiting with bated breath.
Absolutely. And as you say, and I didn't realize this was the fourth time that the court has held this over. So clearly there is perhaps a lot of conversation and consideration. And, we talked with Damon Root recently from Reason Magazine about this case. He pointed out that this shouldn't be a close decision. After all, in the Heller case, D.C., the Supreme Court did rule that D.C.'s storage requirements were unconstitutional, and the San Francisco law is, in essence, a mirror of D.C.'s requirements, with the exception that you don't have to have your firearm locked up where it can't be used for self-defense as long as it's on your person. That's the only difference, right?
That is the only difference. You're allowed to unlock it, but in the middle of the night, you still find yourself in the exact same position with your handgun having to be locked away in the middle of the night, and only when you hear the glass break in the middle of the night can you then scramble to retrieve your firearm and then try to unlock it and use it in self-defense. And we thought this was an excellent case to bring, obviously, in light of the Heller decision, particularly if you remember back to oral arguments during the Heller case when the counsel for the District of Columbia, he tried to make the argument, well, look, there's an implied self-defense exception that obviously we're not going to prosecute someone if you use your firearm in self-defense. So right then the Supreme Court justices, I believe it was Justice Scalia and Roberts, interrupted him and said, so how does that work then? You hear the glass break at night, and then you fumble for your reading glasses, you turn on the light, and then you try to fix the combination. Is it a combination lock? And the gallery, burst into laughter, and obviously the court's point was made that that's not a reasonable solution here, and so much so that the counsel for the District of Columbia didn't even continue pressing that argument.
All right, well, maybe Monday we will get the word of the Supreme Court. Now, they don't have to agree to hear this case, right? They could simply come back with a summary judgment against the Ninth Circuit's decision here?
That's right. It's called a summary reversal, and essentially that would just allow the court, without accepting further briefing or having oral argument on the case, just putting together a straightforward opinion saying, look, Heller was very clear on this, and we're just going to overturn the Ninth Circuit's decision and strike down the law without actually having full briefing and hearing.
Okay. All right. So in the meantime, the Supreme Court, considering this case, next week in the Ninth Circuit Court of Appeals, which is where the Jackson case was heard and the storage laws were upheld by the Ninth Circuit, we've got oral arguments in the en banc rehearing of the Peruta case as well.
That's right. The court recently issued an order scheduling the en banc oral arguments for Tuesday, June 16th at 3:30 p.m. So we're busy preparing for the oral arguments in that case. We're fortunate enough to have former Solicitor General Paul Clement arguing that case for us, so we're looking forward to it.
Absolutely. And Clint, we've also got the case out of D.C. yesterday afternoon. Judge Scullin in Syracuse, New York, issuing an injunction against the district in their requirement that people show good cause for getting a concealed carry license. Again, very similar to the good cause requirement there in San Diego County. The judge there said, look, even under an intermediate scrutiny review, this does not withstand constitutional muster. This is an infringement on the right to keep and bear arms. There's some speculation as to whether or not this case could be the next one to go before the court. I won't pretend to guess which one could go before the court first, but clearly these are very live issues at the Court of Appeals level right now. I mean, you've got the Seventh Circuit Court of Appeals decision that said the blanket ban on the carrying of firearms in Illinois was unconstitutional. We had the Ninth Circuit decision, but again, that's going to be reheard. But there's a lot of conflict here. Does that make it? That should make it more likely that the Supreme Court will hear one of these cases, right?
Definitely. I mean, we already have a circuit split on this issue, and now this district court decision in D.C. after the D.C. Circuit initially struck down the complete ban on carrying firearms, and then D.C. put into place the good and proper requirement, which means, effectively we can bar anyone we want from carrying a firearm for self-defense. And so the court striking that down, which was so similar to the law at issue in our Peruta case, that's huge, and we're going to be providing notice to the court of that in the Ninth Circuit, absolutely. So, that just further shows that there's a split between the courts on this issue and that there's just absolutely screaming for a Supreme Court review.
Talking again with Clint Monfort of Michel Associates, were you, obviously you were pleased to see the judge's decision there in D.C., but were you struck by anything, any of the language that the judge used in his decision granting that injunction?
Yeah, particularly on, as you mentioned, he applied intermediate scrutiny. And under intermediate scrutiny, some courts use this, anti-gun courts have been using this to uphold virtually any restriction on the right to keep and bear arms. But the court went to great lengths to explain that under intermediate scrutiny, you still have to show that the law is narrowly tailored to achieve the government's interest. It's not just good enough to show that we have an interest in that, that it may be likely. You have to prove that the restriction doesn't burden substantially more conduct than is necessary to achieve the government's interest. And that's part of the intermediate scrutiny equation that a lot of courts have kind of been skirting. And Peruta made a point of this, and now this court has made a point of it as well. So it was good to see that language in there and a court taking note of what burden the government is really held to under intermediate scrutiny.
Absolutely, because I know that's been one of the sort of the wonky discussions that has taken place since the Heller-McDonald decision is, all right, so how do we view these gun laws? Is it strict scrutiny? Is it intermediate scrutiny? And in a way, Clint, I guess from, I'm not an attorney. I don't even claim to play one on TV. But in a way, does it matter as long as the court is willing to say, look, even under intermediate scrutiny, we're talking about a real significant right here? I mean, I know that it matters, but it also seems like it's a pretty important development that here we have a judge saying that even under the less heightened scrutiny, that is not strict scrutiny, but even under that sort of middle ground, this still violates the Constitution.
That's right, and similar to what I was mentioning a moment ago, it's if they're willing to strike it down at intermediate scrutiny, that kind of puts more of a warning out there to governments that, look, you're not going to be able to just violate Second Amendment rights and skirt having your laws struck down just because courts might be willing to apply intermediate scrutiny as opposed to strict scrutiny. Strict intermediate scrutiny, properly applied, has teeth too.
Well, that's a really good point, because you're right. We have seen some judges around the country try to say that intermediate scrutiny just sort of allows, if there's some sort of compelling interest, then a lot of deference is given to whatever lawmaking body, whether it's a state legislature or a local city council. But a lot of deference is given to those governmental authorities in establishing their laws, because they say, well, look, we have an interest in public safety, right? So therefore we should get to do whatever we want. We saw that actually in the case recently out of the Seventh Circuit that upheld the authority of municipalities, I think, in Illinois to ban semi-automatic rifles. And the court said, yeah, we don't have any evidence that this actually does anything to make people safer, but the fact that it makes people feel safer is a compelling enough reason that the ban should be upheld.
Right. And I mean, that just goes to the point exactly of why clarification on the standard of review for Second Amendment claims is really in need of review by the Supreme Court, because courts are just kind of all over the place, and you have, one court going one direction, one going another direction if they want to uphold a law or strike it down. But what was interesting in the D.C. decision this week is that the court made clear that while there is some deference to be given to a legislator's policy choice on whether or not a law may or may not be effective, that deference cannot and should not be given in deciding whether or not the law is narrowly tailored. and whether it burdens substantially more conduct than is necessary. That's a burden that's on the government, and the government does not get any deference on that point. So it was great to see the D.C. court calling them out for that.
You bet. All right, Clint. Thank you so much, sir, for coming on the program. It's a real pleasure talking with you. Thanks for everything you do.
My pleasure. Thanks so much for having me, Cam.
You bet. We'll talk again soon. And give our best to Chuck Michel, Clint Monfort of Michel Associates, joining us talking about some of the latest legal activity regarding the right to keep and bear arms.